welcome to all of our members of the community, the audience. My name is John Nockleby. I'm a professor of law at Loyola Law School. I also direct the Civil Justice Program and the Journalist Law School. And Adam,
I'm Adam Zimmerman.
Yes.
And I'm Adam Zimmerman. I'm also a professor of law at Loyola Law School, where I am the associate director of Loyola's Civil Justice Program, where I teach torts and civil procedure and mass torts and administrative law. So.
Great. So for those of you who've just logged in, just a couple of housekeeping matters. First, please feel free to wander about and pick up some food at the back of the room if you like. That'll be courtesy of, the food is provided courtesy of Loyola Law School, so help yourself to food and drinks. Also at the bottom of your screen, you'll see a Q&A box that you can pop in questions about any matter that we are talking about, or maybe there are questions that we haven't thought of that you might want to pose. And you can also use the chat box. I see somebody's asking if there's a vegetarian option. Oh yes, there's a vegan option. There's vegetarian as well as vegan. So we've covered the waterfront. And there's some libations that may have some alcoholic content associated with them. So have fun with that. So we are, both of us, Adam and I, deal with civil issues. We're not criminal law experts by any means, and so we're going to be talking mostly about immunities in the civil context. And originally our thought was to just talk about potential immunities to civil litigation relating to torts and other statutory causes of action that resemble torts, but particularly given the events of the last few weeks involving the police violence issues. We're going to be talking a little bit about 1983, Section 1983, the civil rights statute that protects people's constitutional rights from being deprived under color of state law, and the immunities associated with that. But the goal is to talk primarily today about immunities from civil litigation.
The other major topic that we talked about is immunities, particularly in the conversation that we're having about coronavirus.
Yeah.
Both privately through contract, at the state level, where there is a lot of action taking place, both in state legislatures as well as in governor's offices that are providing immunity shields for various things related to the coronavirus, as well as at the federal level. So this will be taking on some of like the really big issues of our time right now, police brutality and how the law responds and some of the things that are happening in the face of an historic pandemic.
So here's a Law 101 question that we should really address. What is an immunity, Adam?
Well, an immunity is a legal status where an individual can't be held liable for a violation of the law, even if all the elements that would normally be needed to establish a tort or negligence or any other form of liability were met, and even if there were no other defenses available to the defendant. Mm-hmm.
So it's a status-based distinction, in other words.
That's correct. And there's two important forms of immunity. There are absolute forms of immunity. Those apply to the state, but the state has sovereign immunity. Prosecutors have absolute immunity as well as representative judges. Yeah. They have forms of absolute immunity. And then there's also partial and limited forms of immunity that we call qualified immunity. And so I think that's actually a good segue for you to talk a little bit about what's happening with qualified immunity. What is it? What are some developments that are going on with qualified immunity today?
So it's come up a great deal in the context of suits against the police for unnecessary or unwarranted violence against other people, and we've seen this in the Floyd case and some of the other cases around the country. And there's obviously been tremendous demonstrations and with the various movements, the Black Lives Matter movement and so forth, to address what is often regarded as unwarranted police violence, shootings, using batons against peaceful demonstrators and so forth. So it would typically be the case that if someone were suing a police officer in their individual capacity, and we'll put aside for just a moment suing their employer like a city or a county, for which there are different standards. One would ordinarily bring a cause of action under 42 USC section 1983, a congressional statute that grants federal courts and also this is applicable in state courts. It's a federal statute, but it can be filed in either federal or state court, that grants a cause of action for an individual who claims they've been deprived of their civil rights, their constitutional rights, and certain other federal rights because of somebody operating under color of state law. And that usually involves state action, state actor, somebody like a police officer who's imbued with state authority. And so in order to establish the cause of action, you'd have to show an intentional deprivation, such as a violent act against sticking somebody's knee in your neck for 8 minutes would be, or shooting somebody in the back, as happened the other day in Georgia. Now, the officer has, according to the United States Supreme Court, what's called a qualified immunity. And we'll get to what that means, but I want to first address how this came about, how the qualified immunity came about. It really was not in the statute at all. So this was a congressional statute that's been around. I want to say since 1870. I hope I have that right. It might be 1866. And it hadn't been used a great deal.
1871.
Thank you. I was a year off, I guess, or 5 years off. And it was not used greatly until Monroe v. Pape in the early 1960s. But soon thereafter, in 1967, the United States Supreme Court grafted onto this statute a provision that was a development of statutory interpretation that Congress must have intended to provide what was called a good faith immunity for police officers and other public officials doing their job. And so this qualified immunity was predicated upon the idea that even if you had deprived somebody of a First Amendment right or right to liberty or life, if you did so in good faith, you would be immune. And so that good faith immunity, which held sway for about 15 years, was required the officer to say, I acted in good faith, and then that would have been a subjective/objective standard. Now, in 1967, I'm sorry, that was when that was created. So 1982, 15 years later, in a case called Harlow v. Fitzgerald, the Supreme Court expanded that beyond good faith, and suddenly it became just an objective reasonableness standard. What that meant was that the officer could not be held liable unless there was a prior judicial decision that had specifically held that the very conduct at issue in the case at hand was unlawful or unconstitutional. And if this is the standard, it means that if it's unconstitutional and found to be unconstitutional for a police officer to sit on somebody's neck for 8 minutes until they're dead, if that's found by the courts to be unconstitutional, then the next case that comes along where some officer only sat on somebody's neck for 1 minute would be potentially created differently. So, in other words, it would be very difficult to establish that a case had been clearly decided previously. Now, let me give you an example of that shows the, for at least some of us, the obscenity of this particular standard. There was a case that arose in California where police officers were executing a warrant on a couple of businesses. And in the course of that, they stumbled upon some rare coins and cash. And they reported they had found $50,000 and then put that into the, dealt with that appropriately. But another $200,000 of coins and cash disappeared. And when the owners discovered it, the owners were never prosecuted for any crime. They brought a 1983 suit. And they said, we're suing the officers for depriving us of our property without due process, without reason. And the officers claimed good faith immunity because it had never been squarely held that officers of the law who steal while executing a search warrant would be committing a violation of law. So they were released from liability on grounds of the qualified immunity. Another example that is an outrageous example that went up to the Supreme Court was eventually a review was denied, but it went through the Ninth Circuit. Involved a pregnant woman, a woman who was driving her kid to school. She was 7 months pregnant, and she was stopped for speeding. And the officer, under state of Washington law, required that people who received citations had to sign them. She misunderstood the requirement of a signature. The officer said, "Sign this," and she thought by signing it would be an admission of guilt, so she refused to sign. And the officer said, "If you don't sign, I'm going to arrest you." And she said, "I can't sign that. I'm not going to admit anything." So she refused to sign. So then supervisor was called, who said, "Get her out of the car and arrest her." She wouldn't get out of the car. She said, "Give me the citation. I'm not going to get out of the car." So they had a discussion amongst themselves after she said she was pregnant. "Well, I guess we're going to tase you, but we're not. You know what this is?" She said, "I don't know what that is." "That's a taser. We're going to tase you." They tased her in the arm, they tased her in the leg, and they tased her in the neck, all within a minute of each other. And she screamed, and eventually they dragged her out, slammed her on the ground, handcuffed her. Now, it may seem this is unreasonable force. And most members of the Ninth Circuit said, yeah, that's unreasonable force. There were some dissenters from that position. But the court held that because it had not been clearly established in law prior to this time, that tasing somebody 3 times in a very short period of time was an unconstitutional deprivation or unconstitutional use of force, the officers, even though they committed a clear violation, would have qualified immunity. So there's the basic problem. And there's a further problem. Adam, you might want to address this, the order in which these decisions, is it a violation of law versus the immunity? You might want to address that. We talked about this yesterday.
Yes. There are 2 additional procedural issues that are raised by qualified immunity cases. And I see actually we have a question and answer. I thought this was about COVID-19 immunity, Now police misconduct. We will be getting to that too. We are talking about all things immunity, both as it pertains to police misconduct, but also the new legislation, as well as contractual waivers that pertain to COVID-19. But the 2 additional procedural problems that compound the difficulties of establishing a 1983 case is first, that qualified immunity cases are appealed immediately. If a court denies qualified immunity, unlike any other kind of motion, you don't go to trial. Actually, the government or the police officer has a right to appeal immediately. But the second is, historically, it used to be the case that when you brought that type of defense, the court would first, before even getting to whether you were immune, try to figure out what the law would say in a situation like that. It would say, and that helped develop the law so that we could have clearly established law that we could point to the next time the police officer did something. But about 8 or 9 years ago, the Supreme Court left it up to judges to figure out whether or not they would decide the law first, or instead just determine whether or not the law was so clearly established that the police officer should be immune. And because many courts are now reaching that latter question, the question they used to have to reach later, like whether they're immune, they're not even reaching what the substantive law of 1983 would say under those circumstances. And so what we've created is not only an extremely high bar to asserting a 1983 claim, but we've now created this kind of black hole, this vacuum that's no longer kind of developing the law of 1983, and thereby creating opportunities for a lot of this misconduct to continue. And that has led to calls for reform. I was going to put this up in the chat. Maybe I can put this up in the chat. This is the End Qualified Immunity Act, introduced last week. And in it, it seems to try to undo all of the different legal developments that John traced all the way back to 1967. That act would first not allow officers to have a good faith defense. Second, it would repeal the idea that an objective defense, like the fact that there was no clearly established law on point. It even seems to go even farther and say that even if a police officer would have reasonably believed that the law was X, but it was Y, then even then, there would be no immunity. What do you think about that? I put that up there. It kind of traces some of the developments in the findings. It's a very short bill. It's only about 3.5, 4 pages. But at the very end, it kind of describes this attempt to end qualified immunity. What do you think about this pending legislation and other calls to end qualified immunity?
Yeah, I actually think there's serious issues with providing immunity, partly because the legal standard just to get liability are very high because of the nature of how the liability standard has been established. So even though there is this qualified immunity that basically absolves most police officers from ever being held to account, the liability standards are also extremely high. It almost has to be a malicious act on the part of the police officer that is so beyond the pale that it won't satisfy, and there has to be little conflict in terms of the facts. So we're going to look at this from the officer's point of view. We're going to look at this from the what information the officer had at the time, not what information they could have obtained, and so forth. So there's a fair amount of protection for officers without having any of a qualified immunity. And there's a question about whether the Supreme Court would undertake to re-review this doctrine because it is grafted upon a statute by act of the Supreme Court. And there have been efforts every year for several years to get the Supreme Court to take up a case, including the Washington case with the pregnant woman I mentioned a little bit ago. And so far the Supreme Court hasn't taken up the cases. It could, has the power to, since it created the doctrine. It could also change or modify or
and there's been increasing calls from both sides of the court.
There's a lot of calls from libertarians, calls from Republicans, calls from Democrats. So
Justice Sotomayor's opinion and Justice Thomas's opinion.
Yes, on both ends of the Supreme Court, asking or suggesting reconsideration. So I think we should move on to the next major topic, which has to do with immunities given the COVID infections. Yeah. So, Adam, you want to start?
Yes, I think our first question kind of on this from before kind of touches this off. I thought the panel was going to be about COVID immunity. I'm trying to get back up and running and need to know about, what we can do about contractually regarding vendors and attendees and what the legal ramifications are if someone gets sick in an event. And that's a good way to kind of touch off like what kind of immunities can be provided through waivers. Mm-hmm. This came up recently because the Trump administration in a campaign rally that's about to take place in Oklahoma, maybe I can post a link to it, inserted a waiver And this is actually if I was teaching, this would be the perfect waiver for me to introduce to my class if someone was looking for what not to do. So if one looked at just the bare text of this waiver, the waiver says, among other things, anyone attending this rally agrees to assume the risks and waive all liability. Question, is that enough? Is that enough to waive liability, that language, waive liability for something like COVID, for a negligence case? And the answer is actually no, that language would not be enough. The law in most states, I'll get to the other side, the law in most states actually says that because contractual waivers to negligence liability are disfavored, the contract actually has to be very specific that you are actually waiving negligence. Negligence actually has to appear in the contract. You actually have to say, I am waiving the right to pursue a negligence claim. And state courts around the country have repeatedly said and evaluated the contracts to make sure that they are specific enough. Otherwise, under various doctrines that say that you kind of read the contract against the person who drafted it, or narrowly with respect to the person who drafted it, they say no dice with respect to negligence. But
well, the other thing is that what if I'm assaulted by one of the other people at the rally? This seems to release everybody from any kind of tort. It clearly wasn't intended. I think what they probably wanted to do was to release Trump himself and the campaign and other vendors that might, do something. But, then again, what they're trying to do is to, in case somebody comes into the rally who has COVID and spreads it, to 200 people, that person presumably under this would also have be excluded from potential liability if it were given effect. If the contract was actually drafted correctly. Now, the bigger question is, are these contracts... And this gets more to Hillary's, and hello, Hillary, by the way, former student of mine from the bigger question is, assuming that you drafted correctly, it actually has specific language stating that you're waiving liability. Like, what kinds of contracts will be enforced like this and what won't? And actually, there's an old California case, but the reasoning from that case has been kind of widely adopted around the country called Tunkel v. Regents of University of California. And I like to use the facts of this case to illustrate what factors courts use to think about whether or not a contractual waiver is enforceable. So Mr. Tunkel is being wheeled in to UCLA Medical Center. I can't remember if he had a heart attack or was but it was an extremely important surgery that he was about to undertake. As he's going to the hospital, he's asked to sign a waiver. And when I usually talk about that case, I ask my students, think of all the reasons why that might not be the most ideal circumstances for you to be signing a contract. You have a hospital that's publicly regulated. It's providing one of the most essential services that you can imagine. You're not in very good bargaining position. It's a take it or leave it deal. You're in the unique custody and control of that hospital. The combination of those factors, an essential service that's publicly regulated, generally open to the public, that's a take it or leave it contract that you can't bargain over, and you literally are under anesthesia. There's nothing you can do. You're totally subject to the custody and control of another, are the factors courts usually consider in whether or not to enforce a waiver. So waivers like this are not enforced typically in hospital settings, nursing care, daycare, some other types of landlord-tenant agreements. Because if you tick off enough of those boxes, the courts will say, we just don't think this is consistent with public policy to enforce a waiver. Where the waivers are enforced and where you see them all the time are like ski jumps and bungee jumping, sporting events, recreational events. A lot of those unessential activities. There are cases in California involving people skiing, and the driver of a water skier pulls too close to the shore and they're hurt. That kind of a case, and football, touch football, and so forth. These kinds of things Even though there's some cases in some jurisdictions like Vermont, where even in the skiing context, maybe it's because there's a lot of snow in Vermont, they've overturned those on substantive grounds, substantively unfair. There's some challenges to this, but generally speaking, if the procedures are nicely followed, you give people an opportunity to read it. It's not like hurry up and sign immediately. It's not a 50-page document that they, on the way in they sign something, but they have an opportunity to ask questions to make sure. So procedurally, these are things, it's written clearly. It's not written in lawyer language, but in a way that the ordinary person would understand. And so it's not in the language that isn't common to the person. So foisting onto a monolingual Chinese speaker, something that's written in English without giving them an opportunity to understand what it is they're giving up. Those would be procedural defects. The substantive ones would be things, expanding on, this is the kind of important service that people don't have a choice. They really need this. A public school, where public school education is required, you're mandated by the state to go to school. A public school couldn't require this as a condition for entering the classroom, although they might be able to, and they do require and can require as a condition for engaging in optional sporting activities. So it's that kind of a distinction that courts are making.
That's
so
right.
we have so what's going to happen in COVID?
Well, that's what I was going to say. I think there are really compelling reasons for businesses, at least in those non-essential kinds of activities,
like haircutting salons.
I could see haircutting, restaurants,
nail salons, restaurants.
Nail salons. I could see those places being places where those waivers will be enforceable, so long as, and I mean, if you wanted to really make the waiver protective, you would want to make sure that you afford some of that procedural fairness. So instead of a take it or leave it contract, you might give, like in many car rental agreements, you might give someone the option of something else. So some rental agreements sometimes give the option of buying like a liability policy themselves. Some sometimes allow an option to do something else. But even if that's not possible in many recreational settings, we very likely will see these contracts enforced. Where we won't, where they're going to have problems, and this might be a good way to segue into the next thing I wanted to talk about, is in those places that are very important, highly publicly regulated, assert unique kinds of custody and control over people. And those are in very important healthcare settings, hospitals, nursing care facilities. These are all places that are at the front lines of COVID. And yet I'm not so sure that these waivers would be enforceable under the Tonko Act.
Before we go there, let's talk about what the nature of the liability that you would be attempting to protect against. If you were an operator of a hair salon, for example, or a nail salon. I'm talking about something that is not an essential service in the sense that, well, we may all need haircuts and we may need to get our nails cut. It's not something that can't be dealt with in other ways. So keep in mind that the nature of the liability is probably going to be something like premises liability. It may also be something on the order of I acquired an illness, a COVID-19 type illness, when I entered the premises. So it's going to be a huge causation issue that is, if I walk in to get a haircut and I come out and 5 days or 10 days later, I come down with COVID-19, does that mean I got it from the hair salon? Well, how do we know?
Well,
what other exposures have I had? It's not an unfamiliar problem in tort law. You would establish causation by eliminating all the other possible ways. I didn't go outside. I only had contact with one other person, the person I live with, who doesn't have it, and so forth.
Yeah.
But causation is an issue. But there's a further issue, and this has to do with the effectiveness of a liability waiver. What about the person who goes in and they sign it, but then they contract it and can establish that I contracted it at that hair salon? I go home and suddenly my kids have it. They didn't sign anything, and I didn't sign on their behalf. So, or my neighbor gets it. So there's a problem with a waiver in that at most you're binding the person who's walked in the door and not other people. There's going to be a causation issue. There's a causation link between the salon and the person who got it, and a further difficult causation link. The only possible way the kids could have gotten it or the neighbor could have gotten it is through me, transmission through me. So there's going to be causation problems, but yet liability waivers are going to be ineffective there. So that leads to efforts on the part of various providers to try to get the states to provide liability, not waivers, but liability immunities. Here we go.
Yes, and so I'm going to post this thing from the American Tort Reform Association. And in this website, you'll see this organization is devoted to kind of limiting lawsuits.
Limiting liability, right.
And you'll see how broad the efforts have been within states, both within the governor's office and in state legislatures, to try to limit liability. So far, 22 states have governors have used just their public emergency authority to declare that certain groups for certain kinds of activities will be immune from lawsuits. And I think we're now up to about 14 states. I think I saw that yesterday, was it Arkansas or North Carolina joined? It was Arkansas yesterday. We're up to about 14 states whose legislatures have passed immunity statutes. Let me say, I'll say they have four qualities. So first is like some of them are being made by legislators, some of them are being made by governors, and that's important. And it's important because some of those governors are going to be challenged on the grounds that they might not have had the authority to immunize all of these different businesses from liability. Some of them are quite narrow. So for example, in Kansas, the Kansas governor immunized just doctors, nurses, and other health volunteers who were involved in triage from a potential lawsuit. Others are quite broad. So in Alabama, its governor applied a waiver to any business in Alabama for immunity for COVID-related activities.
Clearly, that will be challenged, and the grounds of challenge just because it's a question of state law, right?
Yeah, the grounds of challenge will be threefold. First of all, these are all questions of state law.
So Alabama is going to be different from Tennessee, different from Utah, different from Montana, and California.
And so the first thing will be, what does a state statute say? You know, because every state has like a public emergency statute. What does it actually say? You know, how long does it last? The second might be, even if the statute's really broad, each state has its own concept of separation of powers. Right. So it's possible that the state law could violate the state's constitution by over-delegating too much authority to
the executive.
Yeah.
Right.
And the third and related point is, it really turns on, that might actually turn on who's being immunized and for what. Right. So if you're being immunized for something very specifically related to, like the public health emergency, again, imagine triage. I can post these two orders if you're interested. Then there's a much stronger argument that it falls within the statute and that it's delegable. But if you're talking about everything, all businesses
that open because we're in stage 4 of our opening.
Yeah, then that's.
I think it's very unlikely that a gubernatorial executive order would survive constitutional challenge. Uh,
Well, but it is
not being an
Alabama,
expert in Alabama
Yeah.
constitutional law.
I just put up the Alabama Declaration so you guys
Yeah.
can see how broad it is.
Most of these statutes, both the gubernatorial executives as well as the statutes, and we haven't gotten to the statutes, but a lot of them do similar kinds of things. To the extent they focus on the healthcare providers for a limited time, dealing just with this particular problem, not all medical problems, but just this particular, whatever led to the emergency of the COVID-19. The narrower they are, the more likely that they would be upheld within the constitutional structure of all these states. And I'm saying that purely because most states have some version of the U.S. Constitutional separation of powers doctrine. They don't just grant unlimited power to the executive.
Right. Go ahead.
I was just going to say there's another limitation that is typically found within both the executive and the legislative enactments, which exempts gross negligence, so they're basically attempting to provide a qualified immunity, limited exemption for mere negligence on the part of the provider.
You anticipated the next point I was going to make. So I said the first thing that all these things you look for is that are they being done through legislatures or governor's offices, because the governor's office might be subject to challenge. The second thing is that there's almost always, and this is also true with respect to some things that have been done at the federal level, there's almost always an exception for gross negligence and willful misconduct. Mm-hmm. The third thing is many of these are not pure forms of immunity in the sense that you generally have to, at a minimum, comply with the existing public health regulations as well as public health guidance to be able to take advantage of that immunity. So but some of these are drafted even broader than that to say you have to comply in good faith. So mm-hmm. Going back to our concepts of like good faith immunity before, even if you didn't comply, but you thought you did, or at least you tried really hard, that might be enough. Mm-hmm. And the final thing that I've already kind of talked about a little bit is it covers different stuff. So, some of the big legislative packages that first came out, like really in the heat of the pandemic, like March and April, were things that were really just, even as a matter of state legislative action, really just focused on hospitals, nursing homes, and other kinds of healthcare providers. But we're now seeing state laws, I can post this article in a second, but we're now seeing state laws that apply to all businesses. So North Carolina, John, Utah, Wyoming, Arkansas just passed much more sweeping legislation that doesn't just apply to health authorities, but to all businesses that might be subject to COVID. Well, we're not seeing in California yet, but
I would really have a lot of trouble with that. I'll say that because if you think about what the potential liability would be predicated upon, it would be negligence. You'd have to establish that somebody didn't fail to do something that they should have done, that a reasonably prudent provider would have provided. And what you have with these kinds of generalized immunities is the possibility that a business might not be complying with the standard protocols of the medical profession, of the healthcare authorities, who may say you need to install plexiglass between the clerk and the customer, allowing only for small windows to pass or to have a credit card. Maybe you ban cash transactions. Maybe there are things that not just plexiglass, but social distancing. You have to have markings on the floor, keeping everybody apart, one customer in the business at a time. There are many different kinds of things. Everybody has to wear protective face mask. And the real problem, it seems to me, is that you have places like Texas where the governor has issued an edict. I just read this. This is from a posting online, so I believe it is true, but I'm not positive, that the governor of Texas issued an executive order saying that local authorities may not mandate the wearing of face coverings, that they can only have it to be optional. I believe that's a correct thing that he actually did, but I haven't seen the order, so I'm not positive that that is an accurate representation. If so, that suggests, at least in Texas and perhaps in other states, that the public authorities are not being as careful as we as a general society might want them to be. And as you know from basic tort law, that just because the public authority hasn't mandated a safety precaution, we still have general common law of negligence, potential liability, that if a reasonably prudent enterprise would have required entrance into the business to wear masks, that would be a ground of potential liability if they didn't require it, if the standard, if a jury found that that was, it should have been done by the ordinary prudent business to protect customers as they entered the facility. So you have the problem with these states that may be enacting, and I take it there are 4 or 5 states that have enacted these generalized liability immunities, is that they're really undermining the capacity of the tort system to enforce standards of public health and safety.
Yeah, I think when I teach torts, this comes up when we talk about doctrines like regulatory compliance, which generally say that just because you comply with a safety regulation, just because you've done the bare minimum, that doesn't necessarily excuse you. Like, you still have to act like a reasonable person exercising ordinary and prudent care. But you know what it also illustrates is that there are many values of the tort system that might be potentially threatened. So John already mentioned that it might be very difficult to show, first of all, that someone was acting unreasonably. It might be very difficult to show that by doing that, you actually caused harm or were the proximate cause of that harm. So there's already a lot of hurdles to even bringing a substantive tort case. But when we think about the values of the tort system, one of them is public regulation. Another is compensation. So one of the things that these broad immunity provisions at the state level might run into is that many state constitutions have open court requirements, and that when you immunize lots of businesses, those open court requirements in state constitutions have sometimes been interpreted to say that people, if they're going to be immunized, they at least have to get some level of compensation. So another problem we have is what this means for compensation. But there's another problem, I think, that's raised by some of these immunity provisions, which is, and it's another value served by tort law, which is that it decenters how, who gets to say what's safe. So like, my mom is in a nursing home. She was admitted 3 days before the lockdown, and I haven't been able to see her or talk to her. Like, she is, by definition, like in the complete custody and control of this other institution. And I am totally dependent when I call them to do anything for her, that on whatever they do in that black hole. I mean, I get texts from mom, but otherwise, what happens inside that facility to me is literally just this big black hole. And the thing that I rely on when I call, in the hopes that they'll just listen to me, you know, that the little bit of leverage that I have in this moment is that California hasn't yet passed an immunity waiver. So I know that, like, if anything happened to her, my chances of her bringing a lawsuit, or whether I really want to bring a lawsuit, are slim. But just having that right, just knowing that I'd be
they
able
screw
to get,
up.
Yeah, that I'd just be able to get them to do something, get my mom her water, make sure that she's breathing okay. All that stuff goes away when we eliminate the tort lawsuit. It means that the bare minimum that they have to do is being dictated by county level public health authorities and the CDC guidance. And so it kind of illustrates one of the things that tort law does. It diffuses state power. It increases the amount of voices that get to have a say in what's safe. What I say for my mom and about what I think is safe no longer matters if I don't have any power at all to stand behind it. It's only the public health authorities. And And if we're worried about whether the public health authorities are doing their job, it becomes it becomes all the more important that we kind of think about like what it means when we're.
Well, there's a further problem in that the public health authorities are not going to enforce. They have thousands of medical facilities, thousands of daycare centers, and all there is it's everywhere, and it makes it impossible for any particular individual to say, look, this institution is screwing over somebody who's under their control.
One last mom story. Here's my last mom story. So in April, an outbreak of COVID took place in my mom's facility. I think they told me there's 100 people in her facility. When the outbreak first happened, they said, oh, we have about 10 staff workers and about 3 other residents. These are all people over 65. My mom was on a respirator. She has a tracheostomy. And I said, okay, well, does mom have it? And they said, oh, no, we're not planning on testing her. And I said, wait a minute, you're not going to test her? It's like, well, we only test people if they get a fever. And I said, well, that doesn't make any sense. Like, a lot of asymptomatic people transmit it. So a lot of people without fevers are going to potentially get her sick. And she's the most vulnerable of the vulnerable. Like, you have to test her and at least take some steps to try to isolate people. You don't want to isolate people who have fevers, for some of which might have different reasons, from ones who don't. It didn't make sense at all. But at the time, there was almost nothing I could do. Like, the only power I had, aside from the potential threat of a lawsuit, was to constantly call the mayor's office. And it was about a week and a half later, after doing interviews with the New York Times and talking to the mayor's office, they finally had a blanket declaration for all the nursing homes that they begin testing people regularly, whether they were symptomatic or not. But if I didn't have the threat of a tort suit, I don't know what I would have done. I don't know what kind of power I would have had to get them to do anything.
Yeah. There are a couple of questions here I want to just address. Alex is asking particularly about the Trump waiver, assuming that they rewrote it. We're not providing legal advice here, but
no. We should have said that at the beginning.
So yes, let us clarify that we're not advising anybody about anything. We're acting as law professors here, but assuming that that it was a valid, would the spouse of an attendee who personally hadn't attended potentially have a suit against the campaign or against the facility or whatever? I don't think there's a question about that. I
don't think there's a problem. The only time there's ever been cases, and I don't think they're California cases, where a waiver extended to someone who didn't sign it are some states that allow parents to sign on behalf of kids. But this is not that type of case. You're talking about one person who signs a waiver, and then another person gets sick, and the waiver doesn't apply to the non-signatory.
Yeah.
It would have to be something else. It would have to be some other form of immunity.
And of course, all the causation issues that we talked about earlier. Somebody's asking, why is COVID-19 any different from another flu, and someone with a compromised system could pass away from the common cold? You won't go after a retailer for negligence just because someone had a cold. I agree. That's right. So here's where the actual legal standard makes a difference. Every facility, every public facility has to provide a facility that isn't dangerous to people. Think about, walking into the front door of, let me go back to my hair salon, where they've allowed ice to build up right at the entrance, black ice, you can't really see it, you step in, you slip and fall. You have an obligation to provide a facility that is safe for the entrance. So if you are not taking whatever the steps are, say again, a hair salon, and I'm not picking on hair salons, just happened to be the example I took. It could be that it's necessary to change that gown that they put on. It may be necessary for the employee as well as the customer to wear a mask. It may be necessary to keep everybody else out, to have one customer at a time in the facility, and not to wash hair, not to provide any service other than hair cutting, and then you have to sanitize the equipment after. All of these are steps that might be necessary under either the healthcare regulations that are absolutely unnecessary because of the common cold.
Right.
And that's because the illness is not only highly contagious, far more contagious. If I recall correctly, this has been a few months now because I was into this intensively a few months ago. I think it's something like 20 times as contagious as a common cold and a heck of a lot more dangerous. So it's the element of danger, the element of contagion that that changes the dynamic from a common cold into and COVID.
Can I add to that really quick? So,
Sure.
I mean, the standard for, I mean, California doesn't have these distinctions anymore, but the traditional standards in premises liability were just distinguished between an invitee, so a business or a place that keeps something open to the public and is being used
About
for
half
purpose.
the states followed the old standard. Yeah.
Licensees, so that's like your home where you let people over, but you're not charging them for it. And then trespassers. And generally the highest level of care applies to the business invitee. They are liable for not only the dangers they know about, but the dangers they should have known about. So if the information about COVID is such that they should have known that in a confined space that people could get this, and to take steps to remedy that, they could avoid it by something like a custom of putting on face masks, that they might be held to that higher standard than, say, someone coming into your home if you didn't know that you had COVID or other people in the place had COVID. If you should have known, that's enough, and that might be enough to hold a business invitee liable for something like COVID.
We haven't had a chance to really talk about workers who like all these meatpacking facilities around the country.
Right.
Not only here,
workers'
but
comp is already a big obstacle to workers bringing claims anyway, because in most states, workers' comp prevents you from bringing lawsuits against your employer. You might be able to bring them against third parties, and then maybe the employer could be let in.
The interesting thing about that, about the workers' comp, is that if you acquired the illness while at work and it is associated with your work, then in most states you would be barred, assuming that you're not in a state like Texas that allows you to opt out of the workers' comp system.
Right.
And you've done so before the incidents here. And also assuming that there hasn't been recklessness or intentionality. Most states have some version of where the employer was reckless or intentional, or various stated in different ways in different states. Then you would have the potential of a tort suit. But there's a question about supposing somebody is fearful. I'm a meatpacking worker, and I'm fearful of going in because they've not done what they're supposed to do. So I'm not going to go to work, and I want to continue to get unemployment compensation. There's an issue, and some states are forcing people to go to work and not independent. If you don't go to work and you're called in, even if you think it's unsafe to go in because the employer hasn't done whatever the appropriate steps might be, we're going to deny you unemployment insurance. Sorry, not workers' comp, but unemployment insurance. North Carolina, to its credit, has determined that if you have a reasonable basis, either for yourself, you have a compromised immune system, or you have reason to think that the employer isn't taking appropriate steps, we're going to still provide you unemployment compensation. But some states are really shifting the burden in a very different way and saying, if you don't go into work, we're going to deny you unemployment for that basis. Then there's another question that Alex is asking in the Q&A, which is, what about these statutes and gubernatorial orders that cover negligent acts because of COVID? Would they prohibit or immunize someone from retaliatory firing of an employee who was complaining that you weren't doing enough, you weren't acting in a safe enough way?
I have to look more at the statutes, because some of the are written very broadly. Some say any and all liability. Others are written far more narrowly. So first of all, the first thing is that's going to be a statute by statute thing. None of these statutes have yet been interpreted. I don't know of any public decisions interpreting them.
There are suits out there that are asking for them to be interpreted, but they haven't come. I'm unaware of decisions out of them. Intuitively, I would make the distinction, though, that if But again, you have to look at the statute, right? Or whatever the regulation is protecting. But I think that at least intuitively, there's a clear distinction between immunizing the behavior of people within a facility based upon COVID versus immunizing the act of firing somebody. That seems to me to be a very different kind of a behavior. But if this is in California, I don't know that I haven't looked at any of the statutes in California per se. I've looked at some of the others.
Well, so California has not, to my knowledge, passed a statute like this. Like I said, there's 14 states. I think one of the links I posted lists all of the states. It's in the Claims Journal link. But California is not one of them. But there are many others, and it's a good question. I think it really is going to hinge on what the statute specifically says. All the statutes are written slightly differently. The one thing I will note, though, because this reminds me of one last thing I wanted to bring up before we leave you all, is that so the action isn't just at the state level. There's action right now in Congress to possibly immunize businesses. There'll be questions about like how far those can go. Like it would at least have to be consistent with the Commerce Clause. So it would have to be some type of interstate connection in some way. But you can imagine many businesses that operate interstate that could take advantage of that. There already is some federal law out there right now that immunizes behavior. There's this thing called the PrEP Act, which was invoked in early March by Health and Human Services by Secretary Azar, and it broadly immunizes virtually any kind of injury related to covered countermeasures. So those are PPE, drugs. So some have gone so far. I follow on Twitter a lawyer who does false advertisement claims. And his question was, could I use the PrEP Act to defend a drug company against a claim that they falsely advertised their product? And the law is written so broadly that it actually says any injury, and it not only says that, but it says so long as you complied with whatever the basic guidance are for making the drug or the PPE, or you reasonably believed you were complying with it.
Yeah.
Right now. So there are some laws out there written so broadly that it could encompass other kinds of claims that are unrelated to getting COVID itself.
With that, I'm going to give you the last word there, Adam, on that issue. But we want to thank everyone for coming to our presentation and joining us for lunch and a drink. Well, this isn't a drink. This is full of pens and and nonsense. But please help yourself to coffee at the rear and hang out. And we'll see you all next time. I think there are going to be a few more of these lunchtime what do they call them? Lunch bites, I guess. But we're delighted to see everybody, and we'll say goodbye at this point.
Yeah,
Thanks
this was
so much,
a lot
Adam.
of fun. Really glad I could participate.
That's great.
Thanks for letting me to do this.
Thank you. Thank you, Adam. We'll say goodbye to everybody.